Welcome to Law Sessions. I am Jennifer Housen. This session covers duty of care in negligence in the law of torts. Now in this session, we will review negligence, which is carelessness for which liability will arise. Now negligence requires 4 elements: that there be a duty of care, that there's a breach of that duty of care, that the breach must have caused the harm, and the damage suffered must not be too remote. We will of course be considering the first requirement, which is a duty of care, and in particular we will look at the concept of a duty of care and how to determine the existence of a duty of care, and we will further consider what are some of the issues in respect of a duty. Now in this first session we will consider the background leading up to the current test. Now no liability can lie against a person unless a duty of care is owed to him or her. And historically, which certainly prior to 1932, the test for whether a duty of care existed depended on whether there was an already defined and accepted duty situation. So for example, a negligent action could be brought in a doctor-patient relationship, it could be brought in an employer-employee relationship, or in a road user to road user scenario, but not, for example, in a next door neighbor to next door neighbor situation, as there was not a defined duty in such a relationship. Now, there was no general approach as to the existence of a duty of care. However, this has changed. Although there has been a change, there is still a limitation to the boundaries of negligence in order to avoid opening the floodgates in what Justice Cardoza famously described in the 1932 American case of Ultramarines Corporation and Touche as exposing a defendant to a liability in an indeterminate amount for an indeterminate time to an indeterminate class, known as the floodgates. Now in 1932, across the pond, Lord Atkin expounded his now famous Neighbour Principle in the seminal case of Donahue and Stevenson, the famous snail in the ginger beer bottle case. The traditional view held by the minority, which was led by Lord Buckmaster, was that no duty ought to be owed. And if we may pause here, Lord Buckmaster was looking at the history of duty of care as a principle. But to carry on, Lord Atkin, who gave the leading judgment, found that the duty of care was owed by a manufacturer to an end user for negligence in the production of his goods. The court allowed Miss Donahue's claim for damages for gastroenteritis and nervous shock. Now, in establishing liability against the manufacturer and in establishing his now famous Neighbour Principle, Lord Atkin said that the rule to love your neighbour meant now that in law you must not injure your neighbour. And the lawyer's question, he says, is, who is my neighbour? And he says it receives a restricted reply. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. Who then in law is my neighbor? Well, the answer seems to be persons who are so closely and directly affected by my act or omission that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions that are called in question. Now that is Lord Atkin's statement, and I would urge you to learn this by rote because it is important. The principle then became firmly established as a departure from the specific duty situations which we have mentioned before, which allowed for a duty of care. And what we had now was a general duty of care. However, the concept of the Neighbour Principle was not so easy to apply as new situations arose. So for example, in the case of Hedley, Byrne and Heller, which we will explore later on, we will consider in a later lecture the principles relating to negligence statements, which is entirely different from this concept set out in Donahue. By 1970, we see Lord Reed in Home Office and Dorset Yachts saying that Lord Atkin's dictum ought to apply unless there was some justification or valid explanation to exclude it. Now, this was seized upon in Anns and Merton London Borough Council. And Lord Wilberforce sought to crystallize the duty principle. And in Anns, which concerned the negligent construction of a block of flats, Lord Wilberforce established that a prima facie duty of care, meaning on the face, was imposed if there was a sufficient relationship of proximity between the alleged tortfeasor and the victim, such that carelessness by the tortfeasor is likely to cause damage to the latter, and there are no relevant considerations which may reduce or limit the scope of any imposed duty. Now, a huge criticism of the Anns test had been that it combined the test for proximity of relationship with foreseeability of harm, whereas Lord Atkin's Neighbour Principle emphasized a need for both a proximate relationship as well as a foreseeability of harm. The Anns test did not make such a clear distinction. Some commentators, this led, of course, to the courts to sometimes ignore relevant policy considerations and to encourage lazy thinking and woolly analysis. This was the view of some commentators. The difficulty with the Anns test is that it appeared too inclusive. So it seemed to apply too easily to cases which might be contrary to public policy. And what you saw in a series of decisions, notably Peabody Donation Fund and Sir Lindsay Parkinson, and in Lee and Sullivan Limited and Aliakmon Shipping, Yun Kun Yu and AG of Hong Kong, the court started what became known as the retreat from Anns. And by 1991, Anns was formally overruled in Murphy and Brentwood District Council. The test now for a duty of care is laid down in the 1990 case of Caparo and Dickman. As part of the judicial retreat from Anns, we see Lord Templeman in CBS Songs and Amstrad, a 1988 case, commenting on the floodgates effect of Anns. He then remarks that the pleading assumes that we are all neighbors now, and he takes it to biblical proportions, saying, Pharisees and Samaritans alike, that foreseeability is a reflection of hindsight, and that for every mischance, in an accident-prone world, someone solvent must be liable in damages. It appears proximity is given undue significance. Now, with Anns truly laid to rest in Murphy, we now turn to the current test in Caparo and Dickman. This current test attempts to reconcile the need for a control device, proximity of relationship with foreseeability of harm. Today, the requirements that must be satisfied before a duty of care will lie were laid down by Lord Bridge in Caparo. At page 568 of the judgment, Lord Bridge said, what emerges is that in addition to the foreseeability of damage, necessary ingredients in any situation giving rise to a duty of care are that there should exist between the party owing the duty and the party to whom it is owed a relationship characterized by the law as one of proximity or neighborhood, and that the situation should be one in which the court considers it fair, just, and reasonable that the law should impose a duty of a given scope upon the one party for the benefit of the other. So then, the current test in Caparo determined the factors needed to be present on the facts, and they are 1, foreseeability, 2, proximity, and 3, that it is just, fair, and reasonable to attach liability. It must be reasonably foreseeable that a particular claimant would suffer the particular type of loss that he did in fact suffer. So whether a hypothetical reasonable person would have foreseen damage in the circumstances, proximity refers to sufficient closeness between the parties in view of the type of loss which justifies imposing a duty. This, of course, is shorthand for Lord Atkin's Neighbour Principle. Of course, if the claimant was unforeseeable, then a duty of care may not be owed to such a claimant, and a good case is that of Borhill and Young. Now, it is fair, just, and reasonable to impose the duty. This refers to policy or public policy considerations. So generally, when the first two are met, it usually means that the third is met also. So if we pause there, if we're seeing that foreseeability is met and proximity is met, it usually means that it is just, fair, and reasonable. But we must consider public policy considerations which will apply here. So the approach of the courts, rather than say specifically that it's policy, find that there was insufficient proximity or foreseeability. The converse can also be true though, that just, fair, and reasonable and the presence of policy can lead to justice for a defendant and reinforce the modern role of the duty of care concept. A good example is, of course, the case of Caparo itself, where the auditor's negligence was argued to have caused the claimant to first buy a significant shareholding and then the entire third-party company. In the case, Lord Bridge, in rejecting the claim, said to hold otherwise would result in an indeterminate amount of liability owed to an indeterminate class of people for an indeterminate length of time. The same floodgates argument we've seen cropping up before. So if a duty was owed to the potential shareholders, or even shareholders as it relates to publicly released information, then what would stop a bank or a merchant who is supplying credit to the company in reliance of the accounts not having a claim as well? If we pause there, this is the indeterminate class and the indeterminate liability that we're talking about in respect of floodgates. So for that reason, it was not fair, just, and reasonable to attach liability in the case. Now, after the break, we will consider other factors relevant to determining a duty of care as well as duty of care in certain situations.